Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we are back in Murray, Kentucky with attorney Jeff Roberts. Jeff, good to see you.
Good to see you, Jim.
Hey, in this episode, I really want to talk about what happens to your workers' compensation benefits if you lose your job or you decide to change jobs.
That's a good question. Actually, I get asked that question from clients and potential clients fairly regularly. First thing that I think people need to understand, because one of the questions I've been asked by a lot of people is, I don't want to turn this in on workers' comp because I'm afraid it will cause me to lose my job. Under Kentucky law, your employer cannot terminate your employment or have any adverse effects against you because you suffered an on-the-job injury, because you pursued a workers' compensation claim, or because you hired an attorney to pursue a workers' compensation claim. So if you've been injured on the job, you should not fear that you're going to be retaliated against because you filed the case under workers' compensation. So people need to understand that right off the bat. But there are certain situations, though, where someone after an injury may lose their job, and so that can come into play, and people get concerned. What happens if I do lose my job? Will that cause me, for whatever reason, will that cause me to lose my workers' compensation case or benefits to stop from that standpoint? And there's several different scenarios that come into play from that standpoint. You know, someone could be terminated for a reason other than pursuing the workers' compensation claim. Just because you've been injured on the job does not mean that you're not still subject to the company policies from that standpoint. So if you just fail to go to work when you've been released and been returned back to work, and you fail to go to work after a period of time, whatever the policy is, sick policy, attendance policy is for your employer, you can be terminated for that reason. So a person could end up being terminated for a reason other than the work-related injury. And then, some people, unfortunately, because of an injury, are not physically able to go back to doing to the same employer that they were. Some people get a different job when they're off work, they apply for a different job, or even if they've gone back to work, they see a job opening and they apply for a better job. And unfortunately, occasionally, sometimes companies go out of business as well, and people lose their job from that. So those are at least some of the scenarios that I've had clients face and have those concerns over what happens. So in regard to, and a lot of these are going to be pretty much the same. The last one's a little bit different, but as far as if you are terminated by your employer for whatever reason, as long as it's not a retaliation. If it's a retaliation because of the work injury or because you hired an attorney for the work injury, then you have a potential, an additional potential claim against the employer for that retaliatory discharge that you, in addition to the workers' compensation claim.
But in this scenario, for instance, you didn't return to work. You decided to go outside company policy, and you basically didn't show up. Maybe you showed up intoxicated. Maybe you decided you weren't going to work. Maybe you got in a fight or an altercation, you did something to get terminated, basically. Right. So let's explore it that way. What happens to the benefits?
Well, if you're, it kind of depends on your status to some extent. It doesn't cost you your claim at all. It does not do that, but it can, in fact, have somewhat of an impact on your claim from that standpoint. Now, if you're off work under doctor's orders, you shouldn't be terminated at that point because you've got the off work slip from your doctor, and regardless of the attendance policy, that should not result in a termination. But if you were already subject to discipline beforehand and you were waiting for whatever the punishment was before the work injury occurred, and then you're off work for the work injury, being terminated in that setting does not stop the workers' comp check from coming in while you're off work under doctor's orders. What we've talked about before, which is technically called temporary total disability benefits. Those would continue on even though you've been terminated from that standing. Now, if your termination is because of some sort of misconduct on your part, then it can come into play on as far as your permanent disability benefits. It doesn't affect temporary total disability benefits. Doesn't affect they're responsible for all of your medical treatment associated with the work-related injury. But under permanent partial disability benefits, a couple of factors the judge is going to look at in determining what you're entitled to in permanent disability benefits is do you have the physical ability to return to the same job, and have you returned or are you capable of earning the same or greater wage? And if you're not earning the same or greater wage because you stole from your employer and got terminated, then they can say, okay, even though normally if you haven't returned to the same or greater wage, your benefits would be increased somewhat. We're not going to give you that increase because the reason you're not working at the same or greater wage now is because of your own misconduct. Now, if the termination is for some reason other than your misconduct, then that doesn't affect that aspect at all. In fact, it can, you don't want to be terminated from your work from that standpoint. But if it is the employer if something other than employee misconduct, then it would not have any effect on permanent disability benefits either from that standpoint.
And just to back up, I'll put a link in the show notes to other episodes where we reference total disability,
temporary
total disability. So TTD is what I was looking for. But basically, that's the time period where you're receiving benefits until you've reached what a doctor declares or decides is maximum medical improvement. You're not going to get any better with medical treatment at that point. And then an impairment rating is assigned, right?
To some extent, that's correct. Temporary total disability benefits pay out until the injured worker either reaches maximum medical improvement or reaches a level of improvement to allow them to return back to work, whichever occurs first. So if you're not at maximum medical improvement, but the doctor says you can go back to working, you're not as good as you're going to get, you're not at maximum improvement, but you can return back to work. When you go back to work at that setting and start earning wages again, if you're then temporary total disability would stop. Now, if you're under light duty, so he says you can return to work, but you can only work 20 hours a week, not a 40-hour week, then you would receive what's called temporary partial disability at that point in time. And what would occur is they would look at your after-tax income from your earnings, and then the workers' comp insurance company would make up the difference. So if your temporary total disability check, and I'm going to use round numbers for ease of figuring, but the temporary total disability check was $600 a week and your after-tax income is $300 a week, workers' comp would make that other $300 to bring you up to the $600 as though you were still receiving temporary total to some extent. And then once you go over $600 a week in after-tax income, even if you're not at maximum medical improvement, the temporary total disability benefits would terminate completely because you're earning greater than what those were.
Now, again, coming back to the termination factor, though, if you're terminated for misconduct, basically once you reach that end point there, and you're no longer with the company, it may in fact impact the increase you could have gotten for not returning, right?
Yeah, it could in fact. Yeah, it could in fact under Kentucky law. Various factors come into play to determine what I call it's not called this in the statute, but what I call your base rate. And then your base rate can be increased by a couple of factors. One is if you don't have the physical ability to do the same job. Another is if you have returned to work at the same or greater wage but no longer doing that. And so the second one, it can come into play if you're terminated because of misconduct on your part. That can affect whether the judge would actually give you, even though you may technically be entitled to it. There's case law that says if employee misconduct is the reason for the termination, then the judge does not have to give that increased benefit in that situation.
Perfect. So let's talk about this. So, I've got an injury here, and I'm not really able to return to work. So eventually, I get terminated. Kind of what happens to my benefits?
That really doesn't have any bearing on the workers' comp benefits. If you're off work for temporary total disability, and the doctor says if you do heavy construction work, and you have a low back injury and had a couple levels of fused in your spine, and the doctor says, look, you're not going to ever go back to lifting 75 pounds on a regular basis. You need to look for something more lighter duty, and the employer gets wind of that, and you're past the Family Medical Leave Act period of time of 12 weeks, and the employer gets wind of that, then the employer can say, look, if he's saying permanently you're never going to be able to do this job again, then there could be a potential for terminating your employment in that setting because you're not able to go back and physically do the job. Now, there's other laws that come into play. Americans with Disabilities Act, they've got to, it's got to be that you cannot do the essential functions of the job. And if you work for a union, then the union can provide protection to where if you can't do this job, but you can do other less physically demanding jobs in that plant, then they've got to make those type of accommodations for you as well. So other factors come into play, but if you're not physically capable of going back to the job and you get terminated for that, it does not cost you the temporary total if you're off work under doctor's orders. It doesn't affect your medical benefits. And actually on the permanent disability benefit, employers have a real hard time, and I see insurance companies do this frequently, where the employer said, look, with these restrictions, we cannot bring you back to work. You can't do the essential functions of the job, so you no longer work here. But then the insurance company and the defense attorney, when we go in front of the judge and said, my client does not have the physical ability to do the job, they turn around and said, well, we know they terminate him for that reason, but we think he does have the physical ability, so he or she shouldn't get the enhanced benefit from that. It doesn't usually go over well with the judge when they make that argument. So in that situation, if the person doesn't have the physical ability to return to the same job, it can actually result in an enhanced benefit under the permanent partial disability, or depending on how restricted the person is because of the injury, could result in permanent total disability, not just permanent partial disability for the person.
That makes sense. Now, we're really addressing 4 different scenarios here that may involve termination. But we're 2 into this now, and I'm sitting back going, this is incredibly complicated. And I'm just thinking to myself, I don't know how I would do this on my own, which is why they probably ought to have their attorney involved. And anytime you're some injuries you can handle by yourself, but it's always better, I think, to pick up the phone and at least consult with an attorney, right? And you do that fairly regularly.
Yes, I think you're correct that it's the insurance company that's paying the benefits has an attorney advising them. The employer in a workers' compensation claim either has the insurance company's attorney advising them, or they have their own attorney advising them in that regard. They know what their rights are.
And they've been through this probably with a whole bunch of other employees, so they kind of know the lay of the land.
Exactly. The insurance adjuster has been trained on this. They know what it is. They have an attorney they can reach out to if there's a question they don't know the answer to. And they know how to ask questions of you that can ultimately impact the case later on sometimes as well from that. So talking to an attorney to at least learn what benefits you're potentially entitled to, and learn what your rights are in these settings is beneficial, even if you don't decide that you don't want to hire an attorney or the attorney that you talk to. At least finding that out is very beneficial, or can be very beneficial to you, even if you don't hire the attorney, as you're going to be better suited in the vast majority of situations, having an attorney representing you, because they're not, the insurance carrier and the defense attorney don't try to take advantage of my clients because they know I know what the law is from that. So, some of the gamesmanship and game playing that takes place doesn't occur when an attorney is involved in the case. From that standpoint, I mean, it's everybody's individual decision, but it's if you sit down to play a game that with friends that you've never played a board game, you've never played before, you're going to ask somebody, you're going to read the instructions, or you're going to ask somebody how's this game played. You don't just start playing the game without knowing the instructions. If you don't come in and talk to an attorney after you've had an injury, it's the same situation. You're playing a game against people who know the instructions and know how the game's played, and you have no clue. And so to me, it's only smart to call an attorney to come in to see an attorney and talk with them. And at least at my office, when I do meet with clients or potential clients, the initial consultation is free. So they can come in, if you call my office, we set up an initial appointment, we talk, you don't get charged for that. I handle cases on a contingency fee basis, so I don't get paid until the end of the case anyway. But if you come in and sit down and talk to me in that initial appointment and you don't hire me, you're not going to get a bill from my office for that initial appointment from that standpoint. And so I think it's important for people to talk with an attorney in these situations. And if you want to talk with me, if you're listening to this and this is the situation you're in and you want to talk with me about that, then just call my office. The phone number is 270-753-0053. We can set you up an appointment either in person at my Murray office or at my Hopkinsville office, or if you want to do it by the phone, I handle cases all over Commonwealth of Kentucky. And so if you're not local to one of those two and you want to talk with me, we can set it up by Zoom. We can set it up over the phone. However you wish to do that, we can get it set up so that we can have that conversation.
And knowledge is power. I mean, I would rather have some information of the lay of the land out there, the games that can be played, and what the rules are.
Exactly.
Absolutely.
Yeah.
Okay, so let's come back to our list. So this is the third scenario dealing with termination and what happens to your workers' comp benefits. And you address this from the outset. Let's say I'm injured and I'm home. Maybe I'm healing. I can't go back to work yet, and I get to looking around and realize, hey, some other companies are hiring. Or maybe I have returned to the job and I notice, well, there's a new plant coming in, or there's a new company coming in, or maybe there's just a good job I heard about, and I decide I want to go apply for that. And then suddenly I get hired by that other company. What happens to my benefits from company A if I decide to go to company B?
And I see that scenario. And frankly, that's one of the situations where having an attorney can be very beneficial from the standpoint that I've sat down, I've represented a lot of people in my 30 years of doing personal injury work and workers' compensation cases in Kentucky. And we'll go back to the scenario I mentioned earlier. You've got someone who's done heavy construction type of work, 50 plus years of age, has done heavy construction type work their entire life, and they've had a back injury, had multi-level fusion in their low back. Even if their doctor has not told them, look, you're probably not going to be able to go back and do this heavy construction, lifting 75 pounds plus pounds every day, I know from doing this for 30 years that's an unlikely occurrence. And then I can sit down and have sat down with clients and told them, keep your eyes open, look around. If you said, because, doctor may release you to do this, but you're not going to do this until retirement age anymore, in all likelihood. Statistically speaking, that's not going to occur. And if you do it for a long period of time, statistically speaking, you're probably going to have another surgery or more problems. Look for a less physically demanding job and use this time while you're off work getting a workers' comp check, recuperating, to try to find that. And I've had clients who have found jobs with other companies that were looking for a supervisor, superintendent type position that the person was certainly capable of doing because of all of their past experience, and applied for that job and were going to be physically capable because they weren't going to have to be on the job site doing all the heavy lifting. And and came back and said, look, they actually offered me this. What's it going to do to my benefits? And so in that type of setting where you find a better job, it doesn't affect your workers' compensation case. If you're off work at the time, and the new employer says when you get released, you can start work with us. You would continue to receive the temporary total disability benefits until the doctor either says you could return to work for the new employer or says you're at maximum medical improvement. Medical benefits aren't affected. They're still responsible for all medical. On the permanent disability benefits, if you're earning a greater wage, then that could affect to some extent. But frankly, the greater wage is going to be better than the increased workers' comp benefit anyway. And I tell clients all the time, you're better off physically, mentally, and financially working than you are not working. And so the person is net to the good, but if they can find a better job and go do that, and it doesn't really have any significant effect on the workers' compensation claim when that happens, usually a positive effect, because frankly, attorneys, or I shouldn't say attorneys, judges are like everyone else, and people like to help people who are trying to help themselves, and if you're trying to help yourself, judges see that, and I think it actually bodes well. If you can't settle the claim and resolve the claim and you have to go to a judge's decision, I think it bodes well in front of a judge when they see somebody who instead of saying, oh, poor me, I can't go back and do heavy construction that I've done all these years, but reinvented themselves into another thing, and I think it actually can end up being a net positive in the case.
That's good news. I mean, because I think there's going to be a lot of that job shifting. And if you've got an opportunity, maybe you just were worried about taking it. Maybe this injury actually is that silver lining. Maybe it is time. Not everybody's going to do that. But again, your benefits are going to travel with you. So that's actually makes it a little bit safer to make that jump if you need to.
Correct. Yes. And I've talked about medical benefits not being affected. And one of the important factors to remember is if you switch employers, the under Kentucky law, except in very rare circumstances, medical benefits are going to continue for a minimum of 15 years. Basically, if you have a temporary injury, they don't continue until after the temporary injury has resolved. But if you have a permanent injury, medical benefits are going to continue for a minimum of 15 years. And if you leave your employment for whatever reason, that doesn't affect your getting the 15 years of medical. And now it's just for the work-related injury. It doesn't cover colds and flus and things of that nature, just the work-related injury and the reasonable treatment for that. But I've had some people who were concerned about going to a better job even after the case was over with and been over with for a couple of years. And they call me up and say, I've got this opportunity, but I don't want to lose the medical I've got for my work-related injury. And I said, take the opportunity. It doesn't affect your medical. And so, and people need to understand that medical is going to continue. Even if your claim's over with and medical's left open, which if I represent you, 99% chance medical is going to be left open, then that takes care of that for you. So,
and once again, Kentucky's workers' comp laws are really set up well for the benefit of the worker. And
some of them are. They've
yeah.
cut the workers' comp benefits down drastically as far as the income benefit. And the medical used to be lifetime until 2018, and then they switched it to 15 years with the option of potential lifetime at the end of 15 years. Total disability and certain amputations and things still get lifetime medical, but most injury cases now are going to be 15 years with the option of lifetime coverage. So
interesting. Well, so let's come to the fourth scenario, and this is the one that I think people really get worried about. Is okay, so I've been injured, I'm getting some benefits, and suddenly my company goes out of business. What happens?
That is a good question. That's the scenario that can have a little bit different take than the other three scenarios. The other three scenarios, there might be some effect on the permanent disability aspect, but probably not. In this scenario, in all likelihood, it's not going to have any effect at all. Because when you're injured on the job, the employer's workers' comp insurance carrier is the one responsible for the benefits. And if the employer goes out, it doesn't affect the fact that the insurance company is still liable for your workers' comp benefits, the same as they would be if the employer had kept on staying in business. So most of the vast majority of the time, that's not going to have any effect whatsoever on the workers' comp benefits. If you if it was a self-insured employer, in other words, they don't have workers' comp insurance coverage, they qualified to be self-insured, which means they have a bank account that's set up to cover with sufficient funds to cover. Then it still should not have any effect because they're supposed to have, in the Department of Workers' Claims in Kentucky monitors this, sufficient funds in that account to cover all of their Kentucky workers' compensation cases from that standpoint. And even if that self-insured account exhaust for whatever reason, then you've got other state agencies that would kick in to cover in that setting. So, and the same as we're talking about if your employer goes out, but another scenario that has occurred frequently, well, I won't say frequent, but has occurred during my career, is if the workers' comp insurance company goes out. And if the insurance company goes out, and Kentucky's got what's called the Kentucky Insurance Guarantee Association, that will kick in and start paying the workers' comp benefits to the injured worker, pay the medical benefits and all of that. So if the company goes bankrupt, or if the company, for whatever, it may just be, if you work for a small mom and pop and they get to retirement age and for some reason can't sell the business to somebody else or doesn't want to sell the business to somebody else, and it goes out of business, should not have any effect whatsoever on your claim. And if the insurance company that is covering your claim goes under, that shouldn't have any effect because what the effect would be a different person, a different entity would be paying the benefits, but it shouldn't affect what you receive. It's just the name on the check is going to be different.
Outstanding. So again, that provides a little bit of sense of security for you there. If you're worried about, hey, times are rough, the business may not make it, you're still going to be okay in terms of your comp benefits.
Correct.
Now, you mentioned, what you got a mom and pop, or it could be a larger company, and they can't find anybody to buy them. If they were to find another company that buys them, are you still going to get your same benefits?
Yes.
Okay.
Yeah,
okay.
If the company changes hands, then you're going to get the same benefits. It's not going to affect the case. There's a local company here that I've handled claims against for years and years. It's gone through at least 4 name changes in my practice. It's still ongoing. I still have cases against that employer now. But the ones that were there when I first started practicing that have medical still ongoing because and that's still being covered through every name change doesn't affect that at all. The fact that the company, your employer may be bought out by somebody else, does not affect the workers' comp benefits that you're entitled to or that you're receiving.
Outstanding. So that's a little bit of a bonus question. We said there's 4 scenarios, but okay, there's the 5th for us.
Yes.
No charge for that one. So it's all good. Jeff, it's always good to come down here and talk to you about this. I mean, as you said earlier, you've been doing workers' comp claims for 30 years, across the Commonwealth. And it's not uncommon actually for other attorneys throughout the state to actually call you and say, hey, I either need some advice or to actually have you step in and handle the comp claim. I mean, I think that says a lot for your practice and the reputation you have here on a statewide basis.
Thank you. I appreciate that. And that does occur. People will call up and ask questions. And frankly, when I was a young practitioner, I did the exact same thing. I'd call people up that were more established than I and more experienced than I and ask questions. And I'm to the point now where that's occurring with me, which is fine from that. But I also have attorneys call up and ask me to represent their family members, friends, or whatever in a workers' compensation case or another type of case that I handle. And one of the things that I'm proud of is because I keep track of the sources of where my clients that are potential clients calling in, And, at least for the last several years, the majority of the calls are either from past clients referring family and friends to me, or other attorneys referring family and friends and clients to me. And, to me, it's a high honor when somebody feels at least thinks enough of what I do and how I do it to refer someone else to me. I consider that to be a very high honor when people do that. So.
Outstanding. Well, Jeff, as always, I really appreciate your time. I appreciate your candid advice here, because, I mean, these are complicated scenarios, and, nobody wants to think about getting terminated for any reason. Nobody really wants to risk that, and especially when you know you've been injured and you feel like you're fighting an uphill battle. It's good to know that the system is out there to kind of work with you and to protect you, and hopefully this information was really helpful. By the way, friends, if you're listening to this and you're in this scenario and you need help, obviously, would appreciate it if you reach out and talk to Jeff. But if you also have some family and friends who may be dealing with something like this, feel free to share this on your social media, because, again, people need to know this information. It's not always being, readily available. People just don't know where to go for these. And this is the whole reason that we do these podcasts, is to provide some really good information free of charge, so that you at least have some answers. Again, knowledge is power. And if you do us a favor by sharing it, we'd certainly appreciate it. Jeff, once again, thanks for your time, and we'll be back in about 2 weeks.
Thank you, and thank the listeners.
Take care. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.